Listen Up with Jim Potts. Listen up, business owners, CFOs, human resource managers, and all managers and supervisors. Jim Potts is answering and addressing your questions and concerns, helping you stay out of court. Furthermore, please be advised that Jim's answers are not legal advice and are only intended as a guide based on his years of experience. The phone lines are open. 1-855-4-J-POTS. That's 1-855-457-6887. You can also email us at listenup@jameswilliampottsllc.com. Ready to listen up? Here is Jim Potts.
Jim Potts back on the air. Hey, listen, let me just tell you, I just got through celebrating 36 years I've been in this business on St. Patrick's Day, actually. I started in this business March 17th I started to say 18, forget that one, of 1980. No, I wasn't around in the 1800s, but anyway, some people may think so. So anyway, yeah, I want to thank all of those well-wishers out there that sent me different forms of communication and flowers and candy and all kinds of different things. I really appreciate that. And hopefully I'll be at this another 36 years, so we'll see. All right, let's get busy. I want to start off by talking about an email I got. Somebody sent me something saying, hey, my employee deleted all of her work emails and quit. Now, this is not an uncommon situation. There are some people to be vindictive that, in fact, will delete all of the emails on their way out the door. Well, just to let you know, is that that's possibly computer fraud. Under the Computer Fraud and Abuse Act, that could be a problem for that former employee. They call it the CFAA. It's designed to prevent unauthorized access or malicious interference with a computer system. So in that particular case, there could be a problem for that former employee, like I stated. Now, the company, though, has to prove that the employee actually caused damage to its computer system or data. So that's the critical part. Did they actually cause some kind of damage? You know, in this particular case, they indicated that the employee deleted all of the work from her inbox. Now, on the face of that, whoever you are out there, that sounds like it could be a problem. However, is what you have to understand is that those deleted emails still can remain in two places. The first place is in the former employee's email trash folder, and the other place is that on the computer's email server. And therefore, if there hasn't been any damage, although it's inconvenient, because you need to check in those two places to see if it's there. And if it is there, well, then you can't take any adverse action against the person. They're not in violation of the CFAA simply because of the fact that there's no damage. So now, had the former employee double deleted, as they say, their emails, then that means that the server would have been wiped clean, the trash bin would have been wiped clean, then that could be a violation. So you need to look at that a little bit more carefully. But I will tell you also that as an employer, is what you need to do as a best practice is to remind your employees that any work emails are company property and that it should be held deleted consistent with your company's computer use/email policy. So if you don't have a policy in place, you need to have one in place. Make sure you state in there about the Computer Fraud and Abuse Act and the fact that any kind of malicious interference with the computer system, etc., could in fact be problematic if anybody decides that they're just going to maliciously delete emails, whether they're still working for the company or in fact whether they leave the company. Okay, so I hope whoever you are out there, I've answered your question, and let's move on. The next area I want to talk about is called odor sensibilities. Odor sensibilities, and more specifically, fragrance sensibilities. There was an issue where an employee filed a claim under the Americans with Disabilities Act. And under that act, the employee stated that she had a sensitivity to Bath and Body Works. You guys know Bath and Body Works, Japanese cherry blossom scent. I mean, that's very, very specific. The Japanese cherry blossom. Now, I know my wife has that. And you should have seen us trying to smell the bottle to see what the big deal was. But this particular person stated that, in fact, she had a asthmatic reaction to that Japanese cherry blossom scent. Now, this went into court. And basically, the allegation spanned a period of a couple of years. So this person says that it was for 2 years that this went on. Now, the court found that the plaintiff's only alleged problem was asthma triggered by this, in fact, Japanese cherry blossom perfume, because that's what it is. And apparently only when worn by her co-workers and not by anybody else. And you have to say, wait a minute, hold the phone here. How is it that if somebody, at a restaurant sitting next to you has it on, that doesn't bother you? Why would it bother you only if your co-workers were wearing it? So the court kind of scratched their head about that. Now, the court in this particular scenario was concerned that whether or not she had a disability under the Americans with Disabilities Act. That's where their concern was. Now, this business about an employee should be warned that these fragrance sensitivities really can be considered disabilities under the ADA, and they need to be taken seriously. So whether or not, in my opinion, it's a violation of the ADA, you think about the working environment the people are in, and to me, you don't want any issues at all if you can avoid them about these kinds of things, because if nothing else now, person goes and all of a sudden now they got a workers' comp claim because this thing bothered them somehow, and now they want to file a workers' comp claim also, taking it to a much smaller degree than the ADA. So what do we do? Here's what I would recommend. You've heard me talk about reasonable accommodation. So under reasonable accommodation, in this particular case, the court was complimentary of the employer's attempts to make reasonable accommodations to the plaintiff's sensitivity, noting that it offered to ask co-workers to refrain from wearing the Japanese cherry blossom. And in addition to that, they tried to consult with the plaintiff's healthcare provider, offered the plaintiff more frequent breaks, and made all kinds of offers to help her out. According to the court, the plaintiff was essentially uncooperative and insisted on 2 unreasonable accommodations, which I'll discuss later. The court found that the employer had engaged in the interactive process and had met all of its legal obligations to try to accommodate her. Now look, you got to understand, anytime there's a disability or a perceived disability, you've got to engage in an interactive discussion regarding a reasonable accommodation. Period. All right? It doesn't matter whether or not you agree or disagree with the nature of the claimed disability, whether it's work-related, not work-related, or whether or not you think it's a ridiculous situation, such as, this particular situation with this fragrant sensibility. Now, let me just caution you, though, on regarding unreasonable accommodation. Now, under the ADA, an employee who fails to cooperate in the reasonable accommodation process or refuses a reasonable accommodation loses the protection of the act. That's why it's critical that you sit down with the person and have the discussion. Doesn't mean that you always come up with a solution that individual can live with. It's having the discussion and sitting down. Now, the 2 accommodations in this particular situation that the plaintiff insisted upon were, number 1, and again, this is why the court said it was unreasonable on the plaintiff's part, was that number 1, a 100% fragrance-free workplace was unreasonable, which is what the person wanted. And 2, the person wanted to be allowed to telecommute. Now, for those of you who don't know about telecommute is when you get to work from home. So now this person is complaining that the fragrances were bothering her, and it was only from her co-workers and nobody else. But the solution to the problem was either nobody wears any fragrances or just let me work from home. Now, it sounded to me like this person had an agenda. There's just no 2 ways about it in my mind, that this issue about telecommuting was on her mind and she wanted to be able to telecommute. Stay at home and work. Well, that doesn't work for every employer. Now, on the 100% fragrance-free workplace, the court recognized that this was a very drastic measure, and in any event that there was no evidence that the plaintiff had a serious problem with any fragrance other than Bath & Body Works Japanese cherry blossom perfume. All right? And by the way, she did not allege that she got headaches and congestion from other scents, but not asthma. But she got headaches and congestion from other scents, but not asthma. So, and the asthma, of course, was what the issue was going to be. So the court essentially said in so many words, hey, why ban Irish Spring soap, lemon lime scented shaving cream, or lavender scented Aveeno hand lotion, and a million of other projects with scents that people use every day? If she's really that sensitive, would the employer also have to ban customers or clients who had a smoke-free work environment before coming inside the building? So the court actually took a very reasonable approach to this. So as a result of all of that, what happened? The employee lost, and they should have. But what's the key takeaway from this? The key takeaway is make sure you try to provide the reasonable accommodations, and that's part of the interactive process of sitting down and having the discussion with the employees. Now, let's, as a reminder, talk about this thing about telecommuting. All right. The telecommuting thing is coming up. Telecommuting can be a reasonable accommodation, but is it practical for some employers? It's not, because it may depend upon the position that the person is working and whether or not the employer with a particular individual needs to be a little bit more hands-on. So kind of up in the air about that. And I think each one of those cases, has to be looked at by the facts. Now, the court finally said the plaintiff either refused or failed to respond to offers of reasonable accommodation, so she basically lost her protection under the Americans with Disabilities Act. So there it is. Once again, disability. This stuff is always coming up. So these issues are always coming up. So what do you have to do? Reasonable accommodation. Sit down, have an interactive discussion regarding a reasonable accommodation, and see what makes sense. If the employee doesn't like what you've offered, hey, I want to say in so many respects, too bad. It's the act of having the discussion. That's what's critical. All right, with that last comment, it's time to close out this segment. Well, let me remind you that you can hear us on Facebook at Listen Up and subscribe to us on iTunes. Just search for Listen Up with Jim Potts. And as a reminder, we do take calls every third Friday. We can be reached at 855-4J-POTS or 855-457-6887. We do between the hours of 9:45 and about 11 o'clock. Or you can email us like so many people do. I don't know why people are so gun-shy about calling up, because I think some of them say that they're afraid that somebody's going to recognize their voice. Don't worry about that. Send us the emails. That's fine too. At listenup@JamesWilliamPottsLLC.com. Okay, I'm Jim Potts. I will continue to fight the fight. Thanks for listening, and catch you next time.
Thank you for being a part of Listen Up with Jim Potts. We take your calls every third Friday at 10 a.m. Pacific Standard Time for your questions and concerns. Call us at 1-855-4J-POTS. That's 1-855-4J-POTS. Again, that's every third Friday at 10 a.m. Pacific Standard Time at 1-855-4J-POTS. Like us on Facebook, subscribe to us on iTunes, and link up with us on LinkedIn. You can also email us at listenup@JamesWilliamPottsLLC.com. Until next time, make it a great week.